that we're talking about today. So today's law, the most important new law that's come out is Regulation CF, and this is Title III. You'll hear me refer to it at times as Title III or Regulation CF, or at other times perhaps as, there's a number of different ways, but I may just refer to it generically as equity crowdfunding. This is 9 pages of the 22 pages of the JOBS Act, and in your course materials, if you're following along, we have the entire text of the JOBS Act given to you at the end in Appendix B. But interestingly, it's now referred to as the crowdfunding exemption under securities law. So when people go in to use this law, and it's found, got the text here for you, it's part of the Securities Act of 1933. And basically what the law says is that any transaction involving the sale or offer of securities by an issuer that is under $1 million, that is sold to any investor, with a cap of, during the 12-month period of only being $1 million, you can do this, but there are limits on how much money you can have people invest. There are limits on how you can do it, where you can do it, what you can say, what you can't say. And it's incredible for a 9-page law that the SEC literally came up with about 485 pages of rules and comments interpreting the law. And I have to give the SEC credit. This was a very, very difficult law to interpret because it looks on its face like, go out there and raise money, but you're changing everything that's been done under securities laws for 80 years with no precedent, no backup, no way to know how things are going to be handled. And they actually did a very, very nice job with Regulation A fixing the rules there. Here with Title III, it was a much more difficult process, and there's a whole lot of issues that are still there that have to be fixed. But overall, they did a pretty good job making this a workable law, and we're going to talk about some of those specifics as we go through this in just a second. So let's talk first about the limits on investors, because this is one of those fun parts of the law that the law itself that was passed by Congress and the rules that the SEC put out are actually totally different in a very small but material respect. So if you read, and this is a quick practice point for lawyers who may be jumping into this area who have never practiced in the securities law world before. I remember when I first started practicing law, having one of my mentors, I would go in and I would read the cases and I would come to him and say, this is what I think we should do. And the first thing he would always say to me is, did you actually read the statute? Did you read the law? And a lot of lawyers tend to go right to case law or right to precedent and not actually read the statute or text as the first step. In the securities world, as a securities lawyer, the text and the statute is clearly the first place to start. But there's also the rules that the SEC puts in, which are also, now statutes and in the CFR. But looking at both the law and the rules that apply is incredibly important to make sure that you don't run afoul of one or the other, because in many cases they're not identical. And this is an example. So if you look in the materials, the course materials, and you get to the section, I think it's under where I wrote Section 302, crowdfunding exemption, and then it's Section B, B1 and 2. It says the aggregate amount that's sold to any issuer during a 12-month period. Basically what they're saying is no individual can invest, here are the limits, the greater of $2,000 or 5% of the annual income or net worth of the investor. So if you make $50,000 a year, you're going to have to determine if you can do $2,000 or 5% of your income, which at $50,000 would be $2,500. So it's the greater of the two according to the law. So an individual investor in that situation could invest $2,500. And then it says, if the annual income or net worth of the investor is less than $100,000, and that's read it carefully, if either the annual income or the net worth of the investor is less than $100,000. So if you have a net worth of $1 billion, but your annual income is $50,000 a year, guess what? If either of those is under $100,000, you are limited in the amount you can invest under this law, which seems crazy, but that's the way the law is set up. If either, under the law that was set up in the JOBS Act, of those two are above $100,000, then you are allowed to invest up to 10% of your annual income. Now, very interesting law. When the SEC took the rules, they changed it. and it doesn't seem like a material change, but if you read it and think about it, it is. The SEC actually said if both your annual income and net worth are equal to or greater than $100,000, then you're allowed to invest up to 10% of your income. So it wasn't either, it was both, which actually materially changes the law and the way that it works. Now, all of this sounds like a lot of math mumbo jumbo, and obviously anyone who has an abacus or a calculator would have to be able to figure this out. The reality is when you go online and you go to invest and you go on one of the funding portals to do this, it's going to be calculated for you automatically. I'd like to invest. How much would you like to invest? How much is your annual income? How much is your net worth? Boom, here's how much you can invest. Push the button and you're done. So the math gymnastics really isn't going to happen for most people, but it is part of the law. So one of the other very important parts of the law is that the SEC and the Congress said in Regulation CF that all of these transactions have to be taken care of either through a broker-dealer or through a funding portal. And a funding portal, we'll talk about that a little bit later, is actually something that was created by this law. It's a brand new entity that is like a mini broker-dealer. You're regulated by FINRA. You have to go through certain processes. Every record keeping, a lot of what a broker-dealer does, you have to do if you're a funding portal. But you can't, as a company, as an issuer, do this on your own. You cannot do this on your own website. You cannot do this on somebody's website that's not a funding portal. You either have to have a broker-dealer involved or you have to go through a funding portal. Those are referred to in the law as intermediaries. The intermediary is given a lot of discretion in certain situations, but one of the things that's important is the intermediary is responsible for making sure that the amount of money that's raised is done appropriately, that the amount that people invest is done appropriately. So there's a lot of credence that's put into the funding portal, and because FINRA actually is regulating them, it's very important that those people do things the right way. Only United States companies are allowed to use this law, so this is not a law that's open to people from other countries that have companies here. Now, that doesn't mean that you can't open a subsidiary in the United States to raise money, but there are rules that basically govern how that works about that are way beyond where this goes. Some reporting companies, some public companies that are reporting companies are allowed to use Regulation CF, which is interesting. This was really typically set up to be, I think most people thought, for private companies. But if you're not a fully reporting company under the Exchange Act, you still can use this law under certain circumstances to raise money. Now, how many will? I don't know. We may talk a little bit about later on some of the possibilities of ways that it might make sense for a public company to raise money. And I can give you a very simple example. Let's say you have a public company that has a new product that's coming out, and you wanted to do something a little different as part of your product launch. Why not go to your fan base? Why not take a small, tiny little percentage of stock in your company and go to your fans and say, you know what, we're introducing our next line of product here. We're going to let you not only buy this in advance, but we're going to give you the opportunity to invest in our company and become a part of our growth. Very, very small part of the thing, but for $100, you not only get the product, but you also get a share of our stock. Raise $1 million, but it really wouldn't be so much the company needs the $1 million. It would be more so as a great marketing ploy for the company to go out and do a very quick raise of $1 million, but also find a way to generate some nice marketing buzz and build some brand loyalty from some people. There are a number of companies, types of businesses that are not allowed to use this law. Investment companies under the Investment Act cannot use Regulation CF. Companies that are reporting companies that are delinquent in their reporting cannot use Regulation CF. Blank check companies cannot use Regulation CF. And there is part of Regulation CF that came out of the JOBS Act that's also part of Title II and Title IV of the JOBS Act, is that any company that has bad actors involved, I'll talk to you about what that means in a second, cannot use Regulation CF. Bad actors is something new that came out in the securities laws many of us are probably familiar with, but there is a 23-point background check that has to be done of certain officers, directors, 20% shareholders, certain people in management that are involved with companies. That any of these 23-point background checks come up as a negative, hey, if you've been prosecuted for securities fraud, if you have had the SEC pull your securities license or tell you you can't raise money using exemptions anymore, if you fit into any of the categories, postal fraud's another one of them. If you fit into any of those categories, you're barred because you are a bad actor, which is one of the big investor protections that was put in by the JOBS Act, basically finding a way to make sure that people don't have, the Bernie Madoffs of the world out there going to the public online with a slick website and stealing money. Not to say that can't happen, but the bad actor checks is a very, very good way of looking at, okay, who's actually involved in this company? Let's make sure we vet them a little bit. So that's one of the things that's prevented from doing it. There are some parts of the law that talk about multiple offerings going on by related companies. So, people that look at this law and say, I'm going to do this and I'm going to find good ways to use this more than once, you've got to be very careful about raising money with related companies that are part of this.